the impression. So, Lord, this is what the independence means, my Lord. There should be no reciprocity, there is no obligation, there is no indebtedness. Further, my Lord, this court has further, in more clearer terms, has said in the subsequent paragraphs, which I can just refer to your Lordship, my Lord. Age 263, 263, para 301. Yes. May I read from 299, my Lord? Para 299, page 263. It may be true, my lords, about it, that the Election Commission of India provides its services to certain countries. That, however, does not deflect this court from providing what its founding fathers contemplated and also advocated in various reports. It may be true that the Election Commission of India were appointed for the 4 decades of the Republic and thereafter. Since the year 1993, Election Commission has become a team which consists of Chief Election Commissioner and 2 election commissioners. It may be true in the sense that the President, acting on the advice of the Prime Minister in accordance with the rules of business concerned, has been making the appointment. However, it is equally clear that Article 324 has a unique background. The founding fathers clearly contemplated a law by Parliament and did not intend the executive exclusively calling the shot in the manner of appointment of the commission. This is what your lordships have found in the Constitution bench. 7 decades have passed by. Political dispensations are varying use, which have held the reign of power, have not unnaturally introduced a law. A law could not be one to perpetuate what is already permitted, namely appointment at an absolute and sole discretion of the executive. A law, as Mr. Gopal Singh Karnan pointed out, would have to be necessarily different. In the absence of such a law, does create a vacuum. This is despite the chorus of the voices, even cutting across the political divide, urging divesting of the exclusive executive of the appointment from the executive. We have noticed that the making of a law is ordinarily the power of the legislature. Lordship may exclude that. Come to 303. Political parties undoubtedly would appear to betray a special interest in not forthcoming the law. The reasons are not far to seek. There is a critically vital link between the independence of the Election Commission and the pursuit of power, a consolidation and perpetuation. As long as the party which is voted into power is concerned, there is not unnaturally a near insatiable quest to continue in this saddle, a pliable election commission, an unfair and unbiased overseer of the fundamental exercise of adult franchisee, which lies at the heart of democracy, who obliges the power that be, perhaps offer the surest gateway to acquisition and retention of power. Lord, what can be the more blunt way of putting it, my Lord? That they have an interest. The values that animated of the freedom struggle has to be brought to the home by a new generation who has come to the inspiration relating to fundamental duties. Criminalization of politics, a huge surge in the influence of money power, the role, and Lordship would, when it criminalization of politics, my Lord, Lordship would note, my Lord, 40% of our lawmakers, be it Parliament, be it the state legislature, have criminal cases.
26.
And this court, my Lord, despite taking various steps, my Lord, have not been able to reduce that number.
Not the subject matter.
Yes.
Subject.
Yes, my Lord, very well, my Lord, may I read it.
Tell us, after saying in various paragraphs the need
Yes, my
to
Lord.
exclude the executive, why is it said in 315?
Yes. Yes, Lordship would sign a final name, Lord, in 320, para
The
326.
court is laying down norms.
Yes.
Laying down norms for what? Appointment of
Appointment of,
election
yes,
commissioner.
yes, my Lord.
Why does court restrict it only for a particular period till the law is made?
The
The
till-
court could have
till-
stopped at 314.
Yes.
Yeah, asking you what was the reason that wait in the
No,
mind
because
of
there
the
was no
court?
law at that point of time.
There was no
Till a
law.
law is made.
There was no law.
Yes,
The
my lord.
court says that there is a necessity
Vacuum?
to bring in a law.
Yes, my Lord.
The court is discussing, if you
Yeah.
see Mr. Ansaria,
Yes, my Lord.
309.
Please, your lordships. 309. in a unique provision of person, we are concerned with the devastating effect of continuing to leave the appointment in the sole hand of the executive or fundamental values as the fundamental rights, as we are also considered of the time the right for the court to lay down the norms. In other words, the vacuum exists on the basis of that unlike other appointments, it was intended all throughout the appointment exclusively by the executive was by mere transit or stopgap arrangement. It was to be replaced by a law made by the parliament, taking away. Now the law is to be, my lord, taking away the exclusive power of the executive. My lord, this is what your lordship has said. Whether the law meets this test, whether the law has taken over.
The court finds that it is high time that norm should be laid down.
And it should not be in the hands of the executive alone.
So then why is it said in 315?
315, my lord. That the law will be made, my lord. But law has to be, such law has.
You say that the basis of the order of
Yeah.
the judgment
Yes.
has to be removed, which has not been removed.
My lord.
That is what we find
No,
from
no.
your.
Yes, my lord. Basis
So
of.
this judgment on its bare reading
Yes.
shows that it was only to deal with a particular situation of a vacuum.
Yes, my lord. And how the vacuum is to be filled, my lord?
So tell us.
Guidelines are
how to
laid down.
extend it.
Please, my lord.
How do you extend it beyond
Yes.
the framing of the law?
Yes.
That this has to be the norm and
It, my
the
lord,
parliament
yeah,
has no
yes.
discretion.
No, parliament has the discretion so long as it does not leave exclusively in the hand of the executive.
Your sheet anchor?
Sorry, my lord.
This judgment is your sheet anchor.
Yes, my lord.
It
Yeah.
says that Chief Justice should be there.
Yes. I'm not saying Chief Justice, my lord. There has to be, my lord. What I am saying is it cannot be with the hands of the executive exclusively. What the parliament does, my lord, there are various committee reports on various things. But it cannot be in the hands of the executive as Section 7 says. Section 7 says Prime Minister, a minister nominated by the Prime Minister and leader of opposition. Means, my lord, it is in the hands of the executive and executive alone. I'm not saying that Lordship would issue a
We
mandate.
have the parliamentary debates which.
Yes, I have, my lord. I will show to you, lord.
Let us go to that.
It is in that.
Because it stops at till the law is made by the
yes,
parliament.
yes, my lord.
So what did the parliament consider? How was this judgment considered by the parliament?
Please, lordship. Would your lordship permit me to place that, my lord? Just, my lord. May I read just two more paragraphs and then come to the constituent and the parliamentary debates, my lord? Para 301 and 3 by Justice, my lord, Justice Joseph. Yes. Yes. However, para 301, however, it is equally clear that 324 has a unique background. The founding fathers clearly contemplated a law and did not intend the executive exclusively calling the shots in the matter of appointment of. So, my lord, the law which your lordships had declared, such law made by the parliament cannot be, which gives exclusive power to the executive. It does not meet the test of this judgment. It does not meet the test, the ratio laid down by this, which is called out from the Constituent Assembly debates and the various reports of the before and after the Constituent Assembly. And similarly, my lord Justice Rastogi's view and para 353. Yes, yes. The Election Commission performs para
What was
350.
the final direction of the
Yes, my lord.
326.
lead opinion?
Yes, my lord.
Where do we find it?
326, my lord. Para 326.
326. Lead
Yes, Lord.
options are
Page 270, final relief. We declare, may I read that? that as per the appointment to the post of Chief Election Commissioner and Election Commissioner are concerned, the same shall be done by the President on the advice tendered by a committee consisting of the Prime Minister, the leader of opposition in the Lok Sabha. In case there is no such leader, the leader of the largest single party in the opposition Lok Sabha having the largest number, this norm will and the Chief Justice of India. This norm will continue to hold good till a law is made by the Parliament. As regards the relief of putting the placement of permanent secretariat, etc., not very important.
Still the law is made by the.
Till the law, my lord, I'm not saying that law cannot be made, but such a law cannot be made, my lord, in the teeth of the other findings, which says it cannot be exclusively in the hands of the executive. My grievance is there, my lord, that the constitutional makers, as well as this court in Hon'ble has said, the appointment of the election commissioner or chief election commissioner cannot be in the hands of the executive alone. Now, whether this law, which has been made, has given the power to the executive completely, my lord, and it has, my lord, Section 7 is, so it does not, my lord, satisfy the requirement of, my lord, the Constitution or, my lord, as interpreted by our lordship, my lord, under the various paragraphs. And, my lord, what is the law now, my lord? What was earlier? Earlier it was, my lord, that the President makes on the aid and advice of the Council of Ministers. Now also, my lord, the President makes on the aid and advice of the Prime Minister and a minister chosen by the Prime Minister. There is no change in the position on the ground, my lord. The position remains the same.
No, Mr. Sansaria, if you come back to the prayers once again.
Yes, my lord, may I just come back to...
Commanding the respondent to make a law.
Yes, my lord. Make a law ensuring free...
Ensuring so and so.
Ensuring so and so.
Ensuring so and so.
Yes. And further, my lord.
Does the Supreme Court have the power to say to Parliament, make a law?
No, my lord, it has not, and it has not.
But the prayer was direct Parliament to make a law.
But
in the first place,
yes,
was this prayer maintainable?
My lord, it was not granted, my lord. I will not say no mandamus can be issued to the Parliament, my lord. The law is very clear. There's no mandamus can be, it can be, some vacuum can be filled till a law is made, but that law has to be valid law. I cannot, that's like, my lord, in PUCL and ADR case, other case I've separated. The mandamus was till a law is made, you must declare criminal antecedents, your assets and liabilities. Law is made, you don't need to declare. And that was struck down in PUCL case. Only on the ground that the basis of the judgment, you cannot undo it by legislation, so-called legislation, by retaining the same position. Lord, here also, the position remains the same. Prior to making up the ministers, in other read, para 5,
to assist Mr. Hansaria, my lords, para 308 refers to the mandamus point.
308.
Yes, my lords. 308 and 309.
My lord, may I read, my lord, para 5? There are batch of petitions. In one of the prayer, para 5, in writ petition so and so for ADR, issue appropriate direction order directing, declaring the practice of appointment of Cji-Sc and EC solely by the executive as violative of 324 and Article 14. And that is what your lordship has done. And B, direct the respondent to implement an independent system of appointment of EC, etc. on the line of 255th report at Dinesh Goswami Committee report, etc., etc. And this is what your lordship has said. The various committees have said, my lord. Dinesh Goswami Committee report has said, the Law Commission report has said, my lord. It cannot be exclusively, my lord. Who can be? Parliament will take a call. But it cannot be, my lord, that the executive exclusively had it. 308, would your lordship kindly see the para 308. Yes, Lord, as your lordship has said, my lord.
Prerogative of the Parliament.
Yes, my lord.
To enact the law.
Yes, my lord.
Courts cannot direct Parliament to make a law.
That prayer is rejected, my lord, in para 308, no doubt.
Now, for 7 decades,
yes,
324(5)
yes,
was on paper only.
Yes, my lord.
Court felt that it is high time that certain norms should be laid down.
Yes.
And these norms should be followed till such time a law is made.
Please, your lordship.
Right? The court was conscious of its limitation.
Yes, my lord.
So, these observations which have been made over 300 paragraphs,
my lord,
are these not to be read
Yes.
as justification for why these norms are prescribed till a law is framed?
My lord, till a law is framed, it is, my lord, these norms have to be followed. But when a law is framed,
When a law is framed, then can you say that these norms have been followed,
Lord,
have not been followed?
Lord,
Therefore, the law is
no, these norms flow from the constitutional mandate. Lord, these norms, which are laid down by our lordship, Lord, in various paragraphs, are derived from the constitutional mandate that it cannot be left to the executive alone. That is the mandate of our lordship's court. That if it is left to the executive alone, there is a reciprocity, there is no independence. So you have to have an election commission which is independent. And if you leave it to the executive, the independence is compromised. That is, and if the present, my lord, if the present law which has been made, it is the same position. My lord, there is no difference whatsoever in my respectful submission between the law which was earlier prevailing, except that now it is a parliamentary legislation. Earlier, under the rules of business, it was being done under the same thing, my lord. Under the rules of business, there was no different. The president does it on the aid and advice of the Council of Ministers. And it is done instead of the entire Council of Ministers, the Prime Minister and a minister chosen by him recommends, and that has been made. There is no difference which has been there, my lord. The law which is made can be tested by our lordship, lord, on the touchstone of Article 14 and 3 to my lord, and independence of election commission.
Very well. Proceed.
Yes, my lord. So, my lord, this is what has been held by our lordship, lord, that it cannot be in the executive alone, and then it is what has been done is by the executive alone. Para 353 only lordship may note it. Justice Rastogi in the concurring view said the same thing, my lord. Now, my lord, lordship may see the parliamentary debates. I have put the parliamentary debates in volume 2, my lord, on this bill. Which starts from page 108 of volume 2. Yeah.
Second volume.
Second volume, my lord. Yes. Page 108 starts. At 110, the law minister presents it, and at 111, Randeep Singh Surjewala, it is in Hindi, my lord. May I read it in Hindi, my lord? I have to read it slowly.
$111.
111, no? Because the main opposition is by, my lord, speech is given by Randeep Singh Surjewala. It's in Hindi partly in English.
Well, will you read?
May I read it, my lord? सभापति महोदय, आदरणीय मंत्री जी ने कहा कि सुप्रीम कोर्ट ने कई निर्देश दिए हैं जिसकी चर्चा बाद में करेंगे। ठीक है, चुनाव आयोग को आधार प्रजातंत्र की शुचिता, प्रजातंत्र की निष्पक्षता है। संविधान डेमोक्रेसी जिसको हम प्रजातंत्र कहते हैं, उसका आधार ही निष्पक्ष चुनाव और निष्पक्ष चुनाव कराने वाली एजेंसी चुनाव आयोग है। आप जब भी आप चुनाव आयोग की बात करेंगे तो ये चार शब्द निष्पक्षता, निर्भीकता, स्वायत्तता, शुचिता आपके जहन में जरूर आएगी। सर, आप सभापति जी हैं और कानूनविद के तौर पर सुप्रीम कोर्ट के एक काबिल वकील भी हैं। 140 करोड़ लोगों के इस देश में किसी व्यक्ति के जहन में ये चार शब्द आएंगे। ये कानून है आज माननीय मंत्री जी और सरकार लेकर आई चार शब्दों को बुलडोजर करके बुलडोजर के नीचे कुचलने वाला कानून है। ये मेरा विनम्र आग्रह है। सभापति, इसके पहले मैं भी इसके प्रधान का चर्चा करूं। इंडिपेंडेंस ऑफ इलेक्शन, जिसे अंग्रेजी में कहते हैं अवॉइडेंस ऑफ इंटरफेरेंस ऑफ एग्जीक्यूटिव, हमारी इलेक्शन मशीनरी इन दोनों बातों से प्रेरित होगी। ये हमारे संविधान के निर्माताओं ने कहा था। काश आदरणीय कानून मंत्री जी मेरे, आपके और इस देश के लोगों के नहीं, बल्कि जो बाबा साहब अम्बेडकर ने कहा था और संविधान सभा में जो चर्चा हुई थी उस पर एक नजर डाल लेते तो शायद ये कानून को अभी तक वापस ले लेते या बनाते ही नहीं अथवा लेकर ही नहीं आते। माय लॉर्ड,
impartiality, and sanctity.
and
Sanctity.
sanctity. Nispakshata, independence, nirvikita.
Fear.
Okay. Independence and
Sanctity.
sanctity. Now,
Which is the Hindi word?
Hindi word is nispakshata, nirvikata, nirvikta,
Nirbhikta means fearless.
fearless. I'm so sorry. Fearless, swayatata,
Independence and sanctity.
and suchita.
Sanctity. Independence and sanctity.
Yes. Now, would your lordship kindly come to my lord, page 114. Again, Mr. Surjewala, yes, it violates and negates the rigor and affirmation by the Constituent Assembly by Baba Sahib Ambedkar and other individual honorable members of the Constitution. It goes against the very spirit of the Constitution that it enriched in Article 14. It completely negates and subjugates the Election Commission to the authority of the executive. It does away with, and I respectfully say willingly, and if I say maliciously, the judgment of the Supreme Court in toto. That is why the law is per se like stillborn child. Thirdly, I want to point out, जैसा माननीय उच्च न्यायालय ने कहा, आर्टिकल 14 जो हमारे मौलिक अधिकार का हिस्सा है, जो सत्ता में बैठे हुए सत्ताधीशों के बेलगाम कार्यों पर अंकुश लगाने का सबसे बड़ा तरीका है, यह आर्बिट्रेरी पावर। यह पूरा कानून उस आर्टिकल 14 के लेटर इन स्पिरिट के विरुद्ध है, इसके मौलिक अधिकारों का उल्लंघन है। जैसा माननीय उच्च न्यायालय ने कहा, सभापति जी, अपॉइंटमेंट कमेटी है, अब एक एम्प्टी फॉर्मेलिटी है। इफ आई कैन यूज द वर्ड अपॉइंटमेंट कमेटी, क्या है? माननीय प्रधानमंत्री जी और माननीय प्रधानमंत्री के मनोनीत किए गए और उनके एक मंत्री हैं। गांव की एक कहावत है, क्योंकि ग्रामीण पृष्ठभूमि से हूं और आप भी हैं, आधा बांटे रेवड़ी मुंह, अंधा बांटे रेवड़ी मुंह में अपने को दे। Sorry, my not that reading in
Blind.
Yes.
Andha means blind.
Andha blind.
Andha means blind. What is Bate Revri?
Please distribute the.
Please wait. Sir, you please tell us what is the meaning.
Well, I close my eyes. I am giving it and I am giving it to myself.
Batman is distributing sweets. Reading here.
Distributing sweets to person of
He closes his eyes, my lord, and give it to himself.
Oh, he's giving to his people.
yes, his people.
मूड कर अपने को दे,
Everybody is a small sweet.
अपने को दे, not अपनों को दे.
Say that Andha means the blind person when he distributes. I don't know how far that is relevant because Andha blind man cannot distribute to his own people because he would.
No, it's not in अपने को दे, not अपनों को दे नहीं है, अपने को दे, खुद को दे.
So then he.
He is giving it to himself.
So that's why saying
That's why it is the same. That is what the next line says. If the Prime Minister and his minister are going to be majority in the committee, then why have the committee? Then why have the committee?
He himself appropriates.
Yes.
That's the meaning.
And that is not the answer. If the Prime Minister and minister are going to be the majority of the committee, उन्हें एक जेबी or one pocket.
so you can continue.
Yeah. If the Prime Minister and his minister are going to be the majority of the committee, then why have the committee? Let the Prime Minister appoint everybody. Then why have even the law? It is an empty formality. Now, Lord, may I read last 3 lines? I am saying it with a sense of responsibility. For them, do not want an independent election commission, CEC or OC. They want a pocket borrow. उन्हें एक जेबी चुनाव आयोग, 1 pocket की आवश्यकता है। यह कानून एक जेबी चुनाव आयोग का गठन करेगा। आप जेब से चुनाव आयोग निकालेंगे और आप जब आप चाहेंगे जिस पर प्रजातंत्र के साथ वही करेगा। इस कानून का फाइनल मतलब यही है यह pick and choose का formula होगा. Sir, I respectfully also say that it does not pass any kind of constitutional muster. We have to be aware. This is in August House. After all, we have to be aware as to what we see we are doing or saying and what we are passing. This is manifestly arbitrary. These are ill-conceived attempt. This law is ill-conceived attempt to at the consolidating undue total executive control over the elected body, that is Election Commission. This process is arbitrary, intent is malicious, and result is disastrous, if I can say so. That is what going to happen, sir. And I want to take the liberty of last time quoting the Supreme Court judgment, then the Supreme Court judgment is quoted. And your Lordship may kindly come to my Lord, two more things. At page 119, sir, page 119, Lord. So,
Where is the SOR?
page 119.
Statements of reasons and objects.
Yes, my Lord.
SOR is there?
Bill, I don't think, my Lord, I have it. I'll just get it. I will just get
It's
it. So, not in my file.
We have separate trains.
Just Article 324 of our Constitution, second page of it.
Yes.
Envisages Election Commission of India to be an independent constitutional body vested with the superintendence, direction and control of the preparation of electoral roll and conduct all elections of parliament to the legislature of every state and of the elections of the office of the President and Vice President of India. In the Election Commission, the Supreme Court of India has in various landmark cases underlined the free and fair election to be part of the basic structure of our Constitution. In the Constituent Assembly debate, Dr. Ambedkar pointed out the election machinery should be out of the control of the government. So this is very important. The members of the Constituent Assembly agreed to leave the appointment mechanism to the ECI to the discretion of the Parliament with unfolding of democratic process in independent improve the working of the Election Commission. To this extent, Goswami Committee, National Commission for Review of the Working of the Constitution, Law Commission, as well as the Election Commission of India has proposed. In 1991, the Parliament passed Election Commission Conditions of Service Election Transaction Bill. The Act sets salary of the Election Commission, the Election Commission at the same level as the Supreme Court judge. It did not provide for their appointment process, which continued to be decided by the President. In Anup Barnawal case, the Supreme Court declared that Cie-Sc and EC appointments should be independent of executive control and not done solely by the executive. It mandated a selection process which should hold until the Parliament makes a law. The court directed the appointment should be done by the President on the recommendation of a selection committee. The selection committee will consist of the Prime Minister, the Leader of Opposition and Chief Justice of India. The Election Commissioner and so bill was introduced in the Rajya Sabha on 10th so and assented by the in so. It repeals 1991 and provides for appointment process and conditions. The Act, however, has many issues, and the bill therefore seeks to amend this is the amendment bill of the terms and conditions with introduce the following changes to ensure that the suitable candidate, apart from the senior bureaucrat, also has an just a minute. I'm so sorry, my lord. Sorry. No, sorry. This is the amendment. Bill. I'm so sorry. This is the amendment bill, my lord. I'm so sorry. My line friend gave it to me. This is not what the objection reasons of this bill. My mistake.
Sir, you can read.
Can I?
You can read from here.
I'm so sorry, my lord. No, but I have to give it to my lord. This is some private. What happened to this? This is no. This is some private member bill. This is some. I'm so sorry. This was a private member bill. Not my mistake. I did not say it.
I have quoted in my agenda some part of it if you want to read it.
The
Just read
objection
it.
reasons.
Yes.
It's full. Thing, but
No, it's not full
just
This was a bill to amend.
Okay, can I read, my lord, slowly? There's a 2 paragraphs.
This bill is by
I don't have it.
Prabhu Patil,
Vishal Dada.
private member bill.
It's a private member bill. Sorry, my lord. That's what I thought, my lord. It could not have been, my lord, the bill. It was bill to amend, and this private. It was a private member bill, my lord. Lord, may I read slowly? That's just 2 paragraphs of that objection reason. The matter regarding conditions of service of the Chief Election Commissioner, other election commissioner, the procedure for transaction of business of Election Commission are presently governed by the 1991 Act. The said Act do not contain any provision regarding qualifications, search committee for preparing panel of persons for consideration and recommendation of selection committee for appointment as Chief Election Commissioner, other election commissioner, and other incidental provisions. The Honorable Supreme Court in Hon'ble declared that the appointment of Cs and ECs shall be made by the President on the basis of the advice tendered by the committee consisting of the Prime Minister, Leader of Opposition, and the Chief Justice of India. It has been clarified that the aforesaid judgment that the said norm provided by the Supreme Court will continue to hold till a law is made by the Parliament. The proposed bill inter alia provides for defining various expressions in the bill: appointment, qualification, search committee, selection committee, term of office, salary, resignation, removal, pension of Chief Election Commission, Election Commission, and transaction of business for disposal. The bill seeks to achieve the aforesaid object. So that's all. But it does refer to the judgment of your lordship, Lord, in Hon'ble case. Lord, I was inviting your lordship's attention to the debates, my lord, just page 119, my lord, also.
Debates now,
Yeah.
after having gone through
Yes, my lord. Lord,
so much light.
all that it says, my lord.
In fact, I have been shown by my learned brother certain portions
Yes, my lord.
which leaves a very bitter taste in the mouth.
Yes, my lord.
They are of no help.
I'll not go. All that it says, my lord, that there is no change. Effectively, there is no change. It is the.
They are of no help to you.
Yes, my lord. Very well, Lord. I lordship wanted me to read this, Lord. I just read this. Now, my lord, I wanted to show to your lordship, my lord, from
A written submission.
in volume 1, my lord, the extent of power of the Election Commission. I have made a chart there, my lord. If your lordship come to volume 1, please.
Perhaps there is no dispute on that.
I'm so. Well,
Extent of powers of the Chief Election Commissioner
Yeah.
and the Election Commissioner,
Yeah.
there is no dispute.
no, but the length of power, my lord, it
They
is.
have already told us that they
If
decide.
I have tabulated it. If your lordship just permit me to just place it, my lord, hurriedly. I have tabulated certain. First, my lord, page 13 to 16, there are certain advisory powers
Right.
to the president. The page 13 to 16, there are advisory powers to the president, my lord, regarding disqualification, holding of office or profit, etc. Then similarly, my lord, in the RP Act, regarding delimitation also there are powers. My lord, what is important is, my lord, page 14, serial 5, disqualification on corrupt practice. If I can read, my lord, section 8A, even after disqualification for what period, it is to be on the advice of the Election Commission. So, my lord, it definitely depends, my lord. There are cases where, my lord, for corrupt practice, somebody is disqualified and his period is reduced to, my lord, 5 days, 10 days, he again becomes the chief minister. So that power is there with the election. I'm just going with the width of the power of the election commission.
Nobody is disputing that. Just realize that the Chief Election Commissioner cannot be removed from office
Yes,
except in the manner
yes.
a Supreme Court judge is.
Please, your lordship.
So that gives a clear indicator
Yes.
of
The
the power.
width of the power. My lord, what I have
We need not labor on that.
No, all that your lordship may know, Lord, I have categorized them in 5 categories. There is advisory power, they have a legislative power, they have supervisory power, they have quasi-judicial power, and they have administrative power, my lord, which I have tabulated in this under 5 different heads, my lord. Because in the symbol order, my lord, they have very extensive power regarding symbol, disqualification, which party to be recognized splinter group and which party is not to be recognized as splinter group, my lord.
How long do you propose to take, Mr. Ansari?
Lord, I need to show to your lordship, Lord, that
When you ask for 1.5 hours.
yes. Because I need to show some. I'm so sorry. Very
Very well. Come back tomorrow. Let Mr. Gopal continue.
Very well.
Because otherwise,
I understand. He has.
address tomorrow. Let us conclude with him.
Yes, my lord.
Tomorrow you resume from where you are leaving today.
I'm grateful.
And please be precise.
Yes, my lord. I will be precise. I'm grateful to your lordship.
Yes, Mr.
My lords, I'm very grateful to your lordships as well as to my colleagues for permitting me the time which is theirs. I'll just be brief and I'll just explain what are the submissions I have to make. The first, to respond to your lordship's question about this directions in Anup Paranwal being till law is made. That was the direction that has been passed by your lordships in a series of cases wherever your lordships have found a vacuum. From the mid-1980s onwards, in Velo Citizens Forum, when your lordships found a vacuum with reference to environment, before the Environment Protection Act in 1986, the guidelines your lordships laid down under Article 32 and 142 was still a law is made. The idea was that we have a vacuum, we have international conventions that we are parties to, but to ensure that the Article 21 rights of the citizens are protected and taken care of till then, you will lay down guidelines which will be followed by all civil and judicial authorities under Article 144 until the law is made. The idea is the law will be consistent with what that judgment is. The same thing was followed throughout, and then in Vineet Narayan, my lords, if I can just read, I'll just read the exact language because it's the same language which is reproduced here. When we argued this matter before the Anup Paranwal bench, both Mr. Bhushan and I pointed out to the bench that one of the important aspects of the rule of law is that independent authorities have to be manned independently. The Supreme Court and its judges, the High Court and its judges, then investigating authorities like the CBI, the CBC, etc. And now with reference to the Election Commission. These 3 are the buckets in which 2 of them have that kind of independent appointment procedure, while the third doesn't. The first of that was in 1998 in Vineet Narayan's case, in which para 53, I'll just read para 53 of Vineet Narayan, I'm not going to take your time. It says, on this basis, we now proceed to give the directions enumerated hereafter for rigid compliance till such time as the legislature steps in to substitute them by proper legislation. These directions made under 32, read with Article 142, to implement the rule of law, wherein the concept of equality enshrined in Article 14 is embedded, have the force of law under Article 141, and by virtue of 144, it is the duty of all authorities, civil and judicial, to aid this court. Now, thereafter, in a series of judgments, including, as Mr. Hansaria rightly pointed out, with reference to the those who are contesting for elections, giving affidavits both of the assets and affidavits of their criminal backgrounds. That also came from first a judgment of the Bombay High Court, which was upheld by your lordships. They came with a judgment, they came with a law which implemented only one part of it. So then the court had to be approached again, saying, look, they have not removed the basis of the judgment. They have, using the same argument that they're likely to use today, saying it was until a law has to be made, they have made a law. But the question is, what kind of law can they make? Can they make any law which allows the executive to continue to have the exclusivity in the appointment? The answer resolutely by the Constitution bench is no. The question that can be put to us is, does it have to have the Chief Justice of the Supreme Court or Chief Justice of India or his nominee? The answer is no, it doesn't have to. It just needs a mechanism where the executive is not exclusively in control. This is an interpretation of Article 324 of the Constitution. It is for the constitutional scheme and to sustain Article 21. The only way that this can be gone around is by amending the Constitution. And let me give you an example, my lords. The collegium system came in by way of judgments of your lordships in Scora and then in the 1998 special reference. That judgment, the parliament, that legislation could not go around it. A simple law would not take care of the situation. Therefore, when they had to bring in the NJAC, it had to be by an amendment to the Constitution. They knew full well. I asked myself, if they brought in a law like the NJAC without the constitutional amendment, what would this court have done? My view is that this court would have no option but to say you have not removed the basis. What I've done is I've interpreted the provisions of the Constitution which deal with appointments to the High Courts and the Supreme Court. I've provided for a collegium system. We have provided that concurrence is what consultation will be read as. Now, if they had to go around that, the only way was by amending the Constitution. So that is not what they have done. So my first proposition, my lords, for your lordship's consideration is, if they have not amended the Constitution, and this Constitution bench has given an unanimous judgment referring to Article 324 and rule of law and saying that the executive cannot have exclusivity in selection, without a constitutional amendment, this law cannot stand. That is submission number one. Submission number two is that if you see the flow of the entire judgment, fortunately, my lords, there's an entire contents page in the Anup Paranwal judgment, which shows you what the breakup is. And I think that is critical because it shows all the various aspects that have been considered by the judgment. After taking our submissions into consideration, from para 16 onwards, the court takes the draft constitution and the Constituent Assembly debates. That paragraph of Dr. Ambedkar's, my lords, where he accepts and agrees with Mr. सक्सेना's submissions, in fact, concludes with the following words. If I can just read this to you, it's para 26 of Anup Paranwal, page 165. It says, therefore, in order to meet the criticism of my honorable friend, Professor Saxena, supported by the criticism of my honorable friend, Pandit Kunzru, I am prepared to make certain amendments in amendment number 99. I am sorry I did not have time to circulate these amendments, but when I read them in the House, when I read them, the House will know what I am proposing. The bench goes on to consider all of these aspects. It considers the effects of the Constituent Assembly debates. Your lordships may just take it as read in para 33, the effect of what the debate is and what the agreement by Dr. Ambedkar of Professor Shimalal Saksena's comment is laid down in para 33. They specifically refer at para 37.4 in page 169 that finally we find Dr. Ambedkar acknowledging the existence of a great deal of merit in the fear that guaranteeing a fixed and secure tenure was of no use if there was no provision in the Constitution which would stand in the way of either an incompetent or unfair official becoming and running the Election Commission. In particular, Dr. Ambedkar foresaw the danger of the election commissioners being persons who were likely to be under the control of the executive. So at every stage, after going through that, at para 38, the judgment at page 169 says that a golden thread, this is the phrase they use, runs through the entire proceedings of the Constituent Assembly. At para 50, they make the distinction between the Comptroller and Auditor General and the Cji-Sc because looking at the language that is employed in nearly 15 different provisions of the Constitution, this subject, until law is made, their provision is provided, which is what was there as far as the Election Commission is concerned. It's important to note, my lords, that in 1991, a law was made, but that law was only dealing with the service conditions. That's the issue that arose in the SS Dhanwa and Seshan cases. And then, my lords, I thought one important fact is in para 309, 308 was read on the mandamus point, but at para 309, if I can read that, page 264, in the unique nature of the provision, we are concerned with and the devastating effect of continuing to leave appointments in the sole hands of the executive on fundamental values as also the fundamental rights. We are of the considered view that the time is ripe for the court to lay down norms. In other words, the vacuum exists on the basis that, unlike other appointments, it was intended all throughout that appointment exclusively by the executive was to be a mere transient or stopgap arrangement, and it was to be replaced by a law made by Parliament, taking away the exclusive power of the executive. This conclusion is clear and inevitable, and the absence of law, even after 7 decades, points to the vacuum. Thereafter, my lords, from para 310 onwards, it is noted what are the norms that have to be laid down. And in conclusion, at 314 and then again at 326, they laid down that as far as the exclusivity of the executive is concerned, that is not something that should be entertained. The reason, my lords, that this second proposition of mine, the first is constitutional amendment absent, your law cannot stand. Second proposition is, when the court has said that it was the intention from 1950 that you will not have the entire executive control over the appointment of the election commission, that should have been remedied in 1950 with a law. It didn't come. It didn't come for 7 decades. And that is why they say this stopgap arrangement has now become almost like a permanent structure for 75 years. They note elsewhere in the judgment, my lords, that no political party wants to upset this because when they have the reins in their hands, they want to control it. The opposition comes to power and they say, look, we will control the election commission like you controlled it for the last 2 decades. So the second point, therefore, is that the court notes in the background of this debate, in the background of the entire process that has gone on, and the role of the election commission, a role which the court extracts para and verse of judgment after judgment after judgment, where the court has been forced to step in, my lords, with reference to criminalization, with reference to assets, nota, a whole series of judgments which the court has had to step in because that void existed. Therefore, that stopgap arrangement, now having come to an end by the judgment in Anup Baranwal, this process that they've suggested in Section 7, my lords, does not in any way remove the basis. One last thing I want to tell your lordships is that the most recent example of this basis removal because of a judgment of the court came, if your lordships recall, in the Maratha reservation judgment. What happened is on the 15th of August 2018, the 102nd Amendment Act of the Constitution was passed. That made provision, my lords, in Articles 338 capital B and Articles 342 capital A for the Backward Classes Commission, which is given constitutional status, and for the lists to be prepared for the backward classes in the various states. Now, what those amendments failed to note was there will be a separate commission for states apart from the National Backward Classes Commission. So what happened is, by the wording of those 2 amendments coming in, is that it left it open without any clarity on what happens to the state commissions, and said that lists for the purpose of this constitution will be the lists prepared by the National Backward Classes Commission. The effect of this is all the backward classes who existed in the country coming from the state lists cease to exist for the purpose of the constitution. That is in fact what the Maratha judgment in majority said. They said, now that you have the 102nd Amendment, your state commission ceases to exist, your state lists cease to exist. To repair that situation, Parliament did not come back with a statute like they've done here. They amended the constitution again with the 105th Amendment, which came into effect on the 15th of September 21, barely 4 months after the Maratha judgment. And they brought amendments to both 342 capital A and 338 capital B. This was brought in the correct way. The only reason I'm mentioning this is because we have multiple examples, NJAC and this, are examples where when there is a judgment of the court and the basis has to be removed, when the court is looking at constitutional interpretation, you have to bring a constitutional amendment. I can understand if you're interpreting a statute. This is admittedly a case where there was no statute. In each of those cases, there are more than 30 judgments, my lords, where your lordships laid down guidelines and said until law is made, including Vishakha, sexual harassment. Those guidelines were laid down by your lordships following the Beijing Declaration. Imagine, my lords, if the parliament decided to come with a law which undid what those guidelines are. Clearly, your lordships would say, no, the spirit of our Article 21 interpretation was this, and you had to follow that spirit. That, my lords, is the entirety of my submission. I'm most grateful for the time your lordships have given me.
Tomorrow, Mr.
Please,
Consult,
Your Lordship.
you wanted the next week to respond? Maybe you will be taking the entire day tomorrow?
Yes, we'll conclude tomorrow.
I'll take about an hour, as I said.
Please conclude tomorrow, otherwise it becomes very difficult.
Tomorrow,
Definitely
Very
conclude.
difficult.
definitely conclude.
Can you just make a chart in case of appointment of which authority, constitutional authority?
Yes,
The CJI or his nominee has to be made.
I have a compilation. my
You
lord.
have a comparison.
I have a-
Start with that.
I'll hand it over.
My lords, it's there in Justice Rastogi's
Judgment it is there, but I have separately.
Para 444.
Acha.
Concurring, that chart is there. He
That
has
chart is there.
described
Very
Yes.
good.
Para 444. We had given it to the court and it's been reproduced.
Yes.
Very good.
In fact, yes.
So tomorrow,
After the fresh matter.
tomorrow, we also have, my lord, 2 o'clock.
Can I respond next Wednesday, my lordship?
Next week, not any fixed time, my lord. Other than not, they're at loggerheads, they're unnecessarily banging their head against the walls. The family, my lord, whatever your lord.
Any time, Mr.
I know, my lord, I know. That review petitions,
Please.
I think any one day, my lord, if you, 1 hour is the only slot I seek, your lord. I know that the board is jammed, my lord, and I'm fully, but they're fighting like cats and dogs. That's the only thing.
You asked for open hearing of the review. We granted.
No,
you.
we prayed, my lord.
We granted. it.
We prayed on
No.
Of course, my lord.
We granted it.
Right.
Yes, that
Good.
was your.
I see.
It all depends on the
Yes, my lord.
gravity of the matter.
Yes, of course, my lord. Greatly.
Private parties fighting between each other.
Yeah, it's not new.
It's nothing new.
Greatly. Greatly.
Yes, judgment round. After noting the facts and the orders passed by the authorities, this is what we have said. We have found one little fault in your process. But at the same time, we have said that that fault does not change the nature of the misconduct that doctor had committed. Since it is apparent, we did not send it back to you. There was a misdeclaration in that form. So ultimately, this is what we have held. The order we propose to pass is not to fault the process undertaken by the MCI, but to ensure complete justice between the parties, having regard to the fact that doctor is 76 years of age, punishment was passed 10 years back. So in exercise of powers under 142, we have requested the National Medical Commission to reduce the punishment imposed by the Executive Committee and to issue a censure or a warning. And we have granted liberty to that effect. The appeal stands allowed to the aforesaid.
I'm okay.
Obliged.
This would not have been possible without your cooperation.
Your Lordship, my pleasure.
Thank you.
This, I know this is not the appropriate moment, but Your Lordship, in the peculiar facts, with so
142.
140.
No, 140
Sorry,
will
my bad.
never be a
My
precedent.
mistake. My mistake then. Obliged.
My lords, with your lordship's leave, just before Mr. Hansaria starts, I have a small request. My lords, I am away on a personal engagement. There's a wedding in the family. I'm away. But tomorrow, particularly difficult. If after Mr. Hansaria finishes, can I just have 10 minutes after he finishes?
It's
I've
all
just-
up to your colleagues on
I've
the
made that request to them as well.
side. You persuade them.
I've made the request to them. As long as your lordships are fine with it. Very well.
Very
But now, heat.
There is no heat.
There is no heat generated now. We have. No. My lord is saying whether there is heat in the courtroom now. There is no. Please, your lordships.
You have to be very careful now in court
Yes, my lord. Yes.
because everything that we utter
Yes, my lord.
gets reported in 10 minutes.
Yes, my lord. Yes, 10 seconds, my lord.
Whatever happened in the first session is already reported.
Oh, I'm. That's why, my lord, the Chief Justice said it before the matter was called out. He said that media has to be, I want to say something to the media, that they have to be careful about what they report.
Yes.
Yeah. Lord, can I, my lord, request your lordship to take the compilation of documents, my lord?
Volume 2.
Volume 2, my lord. Yes, volume 2.
Identify by volume number.
Yes, volume number, my lord. Please, lordships. Lord, here first I want to invite your lordship's attention to the few meetings of the Constituent Assembly committees, my lord, and some Constituent Assembly debates as to what was the anxiety of the constitutional makers, my lord, the founding fathers. If your lordship kindly come to, my lord, page 3, which is part of the minutes of Fundamental Rights Subcommittee dated 29th March 1947. At page 3, clause 8.
Yes.
Clause 5 of Article 5 of Munshi's draft was taken up. The committee came unanimously to the following conclusion. Universal adult suffrage must be guaranteed by the Constitution. Elections shall be free, secret and periodical. Now, 3 is important. Elections shall be managed by an independent commission set up under the under the Union law. Well, it's very clear, my lord. Now, lordship may kindly come to, my lord, next page, page 5. It is the minutes of the meeting of subcommittee on 17th April 1947, Minority Subcommittee. Page 130.
The judge of the Calcutta High Court.
Yes, my lord. And he was the Prime Minister of Jammu and Kashmir.
Sir,
Too. Yes, my lord. For a
he
sort.
was also a judge of the International Court of Justice.
Yes, my lord. And before that, he was the legal remembrancer to the government of Assam.
Multiple hats.
And he was the person, my lord, who framed the first constitution, draft constitution. But we hardly talk about Sir B. N. Rao. my lord.
I have read somewhere that there's one ICS officer from Bengal
Yes, my lord.
who prepared the first draft. Nobody knows about it.
Sir B. N. Rao. He was an ICS officer, my lord.
Sorry.
He said that.
And the Sir B. N. Rao traveled all. And he traveled all over the world, my lord, for framing the first draft of the constitution. And I was also surprised, my lord, that he was made the Prime Minister of Jammu and Kashmir. But then he resigned. He said that my views and the Prime Minister view are on the or the King's view are at variance, so I cannot serve him, Maharaja Hari Singh. Then he resigned after a couple of them. But page 4 is the minutes of subcommittee meeting on minorities, and at page 5, clause 13.
Page 5, clause 13.
Yes, my lord. The election commission should be an independent quasi-judicial body. This is the committee meeting. Now, what is most important is the advisory committee proceedings at page 6, my lord, on 21st and 22nd April 1947. And lordship, may I kindly come to page 7, what Dr. Ambedkar has to say.
Page 7, yes.
Is a part of, my lord, advisory committee proceedings of 21st and 22nd April, and what Dr. Ambedkar has to say. I must say, I attach a very great deal of importance to this clause of adult suffrage, and I do not think we can allow any exception to this. This clause 13 contains 3 fundamental propositions. Whether you fix the adult suffrage at 21, or whether you fix it at 18, or whether you fix it at 13, is a matter of detail and that matter. Now, 21 earlier, at 2018, now we do not know whether it will go further down. I'm sure will be subject to consideration of the Constituent Assembly. When we pass, it does not
Come
mean...
to the second thing.
Yes, my lords. The second thing is important. The second thing is that we have guaranteed of this fundamental right that the election shall be free and elections shall be by secret voting. It shall be periodical election. The third, we have not said that there shall be direct, there shall be indirect. It's a matter of consideration by other states. There may be different opinion. The third is important, Lord. The third proposition, which is fundamental clause enunciates, is that in order that the elections may be free and in the real sense of the word, they shall be taken out from the hands of the government of the day. Nothing can be more clear than this. And that they should be conducted by an independent body, which we may call an election commission. We have also given permission to this. We have also given permission in the subcommittee clause 3 of this clause that each unit may appoint its own commission. Well, Lord, the draft article said that each state will have its own election commission, but final constitution 324, it was unified. Now, Lordship may skip over the 5 lines and come. In no other way we can be in position to exert such influence as we ought to exercise in the formation of the government, executive and legislature. I am sure it is that our elections cannot be independent unless and until the question of election is taken out from the hands of the government of the day. This is the intention of the constitutional makers, my lord, the founding fathers. And C. Rajagopali agreed, my lord. What Dr. Ambedkar said would be agreed by everyone. I don't need to read, my lord, further. Lordship may kindly come to the next page. Page 9. The chairman, immediately after Ambedkar's reply, the chairman, there is no difference of opinion on the merits of the proposition that you have enunciated. I entirely agree that there should be due safeguards, there should be adult suffrage, and there should be free and fair election and secrecy of voting. The only question is whether it should be fundamental right. You will have all support of the Constituent Assembly. Now, Lordship may kindly come to the next page, my lord. Page 10 top. I quite appreciate what Dr. Ambedkar said. This is what the chairman is saying. There are reasonable grounds for this apprehension that elections are not free in some places and the government of the day or the government in power influences election. Elections should be free and franchisee should be adult franchisee. Lord, there has been, my lord, serious doubts, my lord. Presently, I'm not saying one way or the other, but in the public mind, even in the elections, my lord, there has been nobody at no point of time, my lord, eyes on the election commission has been raised to such an extent as has been raised in the present case, my lord. Then your lordship may kindly come to, my lord, the advisory committee proceedings, which starts at page 11.
Just show us one thing from all these debates.
Yes.
You have just now stressed on page 8.
Yes, my lord.
Unless and until the question of election is taken out from the hands of the government of the day.
Please, your lordships.
Very important.
Yes.
No doubt.
Yes.
But is there anything that the members of the Constituent Assembly discussed about selection of the selectors should also be taken out from the government? Selection of the
I understand, my lord.
Selectors,
yes. No, my lord, it has come, my lord, in the debates. If the government has the say as to who is taking, then
about the election, the entire election has to be taken out from the government's hands.
Yes, my lord.
This is what is sought to be conveyed.
No, it is also said, my lord, electors who will conduct the election. It has come in the debate, my lord. I will show to you, lord.
Show that.
I will show, my lord. Let me
who
go,
will
my lord.
conduct and how their selection is.
Yes,
to
my lord.
be.
Yes.
Because at one place you have shown that it is left to the union.
No,
the law is left to the union.
Law is left to the union, my lord, whether there will be periodical election, there will be direct or indirect election. Only that part. I've shown to your lordship, lord, there was a question whether the MP and MLA should be direct election or indirect election. That should be left to the government. That is what has been said. There is no, my lord, no one has said that it should be left to the government that who would be the election commission. Page 10 I have read to your lordship. Now page 11, my lord. 11,
the third line, page 8.
Yes, my lord.
It is Dr. Ambedkar speaking.
Yes, my lord.
The only thing is that the law shall be made by the union.
Yes, my lord. Election body, which should be, we have given permission.
Law has to be made by the union. That
Yes,
is why perhaps
There is no doubt, my lord.
Article 324.
Court also says, my lord, you make the law, but it has to be, my lord, can't be in the hands of the government of the day. The law cannot be such, my lord, that the government of the day, and I'll show to your lordship, your lordship's interim order shows, my lord, how the selections have been made in this case. After this act was passed, it is on the same day, the leader of the opposition is given a slip of 200 candidates. And at the morning, he is given a list of 6 candidates. And selection is made on that day. Where is, my lord, any meaningful consultation? Your lordship and
That is a separate part.
that's a separate part.
That is how you work out the law.
Yes, my lord, that's a separate.
Your challenge is to the law itself.
Some challenges to the law itself, my lord. I'll come to that later on. That's what I'm saying. My lord, the committees, etc., are very clear that it has to be independent. It cannot be left in the hands of the government of the day. Then page 11, I was showing to your lordship, my lord. It's the minutes of 21st April. Lordship may come to page 12. Again, my lord, whether it should be part of the fundamental rights, etc., that's not very relevant. Now, lordship may kindly come to page 13. The interim report of the advisory committee dated 23rd April, it starts. And the relevant is, my lord, page 14, para 9, clause 3. Superintendent's direction and control of all elections, legislature, whether of union or a unit, including appointment of election tribunal, shall be vested in an election commission for the union or the units, as the case may be, appointed in all cases in accordance with law by the union. Lord, it says by the law by the union. But how the law is to be there, it will come in the debates, my lord. I'll just show to you, lordship. Now, lordship may kindly come to, my lord. Page, the Constituent Assembly debates, my lord, which starts from page 31.
31.
Yes. And at 33, Dr. Ambedkar places the draft article 289, my lord, for consideration by the assembly, which is article 324 today, my lord. And at 34, what Dr. Ambedkar has said, my lord, lordship would permit me to place that. Page 34, Dr. House will remember, my lords have got it, that in a very early stage of proceedings of the Constituent Assembly, a committee was appointed to deal with what is called fundamental rights. The committee made a report that it should be recognized that independence of elections and avoidance of any interference by the executive in the elections to the legislature should be regarded as a fundamental right provided for in the chapter dealing with fundamental right. When the matter came up before the House, it was the wish of the House that while there was no objection in regard to this matter as fundamental importance, it should be provided for in some other part of the Constitution and not in the chapter of fundamental rights. But the House affirmed without any kind of dissent, and in the interest of purity and freedom of election of the legislative bodies, it was of utmost importance that they should be freed from any interference from the executive of the day. In pursuance to the said decision, the drafting committee removed the 3 categories of fundamental rights and put it in a part 289 and 290 and so on. Therefore, so far as fundamental question is concerned, that the election machinery should be outside the control of the executive, there has to be no dispute. What Article 289 does is to carry out that part of the decision of the Constituent Assembly. It transferred the superintendent's direction control on preparation of the electoral roll and all election commission legislature to a body outside the executive to be called election commission. My lord, how can it be a body outside if you appoint that body? Is it an outside body, my lord, independent of the government? Then lordship may skip over that part, my lord. Lordship may kindly come to the next page, page 35. So far as clause, second para of that, my lord, 35. So far as clause 4 is concerned, we have left the matter to the president to determine the conditions of service and tenure of the members of the election commission, subject to subject to one or two conditions, that the Chief Election Commission shall not be liable to be removed, except in the same manner as the judge of the Supreme Court. If the objective of this House is that all matters relating to election should be outside the control of the executive of the day, it is absolutely necessary that the new machinery which you are setting up, namely Election Commission, should be irremovable by the executive by mere fiat. That we are therefore given the Election Commission the same status as far as the removability is concerned as we have given to the judge of the Supreme Court. We are, of course, do not propose to give the same status to the other members of the Election Commission. We have left the matter to the President and to the circumstances in which he will deem it fit to remove any other member of the Election Commission, subject to one condition, that the Chief Election Commissioner must recommend the removal. Lordship, may skip over that, my lord, and kindly come to the next page, my lord, page 36, bottom of the page, my lord. Mr. President has said, what is desired by my amendment? My lord, what was the amendment is? May I read, my lord, what Sibandal Saxena has said, my lord, in the middle of page 36. I have given a notice of amendment to Article 289. At the end of the clause, subject to confirmation by 2/3 of the majority in a joint session of House of Parliament. That is, my lord, the appointment of the Chief Election Commissioner should be subject to confirmation of 2/3 majority in the joint House of the Parliament. After it is should be aborted. Then, my lord, to that reply, Mr. President has said, Mr. President, sir, what is desired by my amendment, that is what Sibandal Saxena is saying, is that Election Commission shall be completely independent of the executive. Of course, it shall be completely independent of the provincial executive. But if the President is to appoint this commission, naturally it means the Prime Minister appoints the commission. He will appoint the other election commissioners on his recommendation. Now, this does not ensure their independence. Of course, once he is appointed, he shall not be removed. Removal except by 2/3 majority of both houses of parliament. There is certainly something which can instill independence in him, but it is quite possible that some party in power who wants to win the next election may appoint such staunch party man as a chief election commissioner. He is removable only by 2/3 majority of both houses on the charge which give him almost irremovable. So what I want that even the person who is appointed originally should be such that he should be enjoying the confidence of all the parties. His appointment should be confirmed not only by the majority but by 2/3 majority of both houses. It is only where a bare majority that a party could move the vote of confidence but in him. But when I want 2/3 majority, then that means that the other parties must also conquer the appointment, so that in order the real independence of the commission may be guaranteed, in order that everyone, even in the opposition, may not have anything to say against the commission. The appointments of the commission and the chief election commissioner must be by the president, but the name proposed by him should be such as to command the confidence of the 2/3 majority of the both houses of parliament. There is no person can come who says staunch party man. He will necessarily have to be a man who will enjoy the confidence of not only one party, but majority of the members of the legislature. Then alone he can get 2/3 majority in support of the appointment. I therefore think that if the real purpose of the recommendation of the Fundamental Right Committee is to be carried out, as Dr. Ambedkar has proposed to this appointment, he must provide that the appointment shall not be made by the president, subject to confirmation by 2/3 majority of both houses of parliament, sitting and voting, so and so. Then, my lord, Sibandal Saxena continues, my lord, to his suggestion at bottom of that page. By this time, nothing will help in this matter. Whoever you put forward will be elected, but we are making constitution forever and not only for today. Today, of course, whoever is appointed by the president on the recommendation of the cabinet will be approved. We are lucky in having our prime minister a man of independence and impartiality, and he will see that a proper person is appointed. But we are not sure that the prime minister will always be such a personality. I want that in future, no prime minister may abuse his right. For this, I want to provide that there should be 2/3 majority which should be approved should approve the nomination by the president. Of course, there is a danger that where one party is in a huge majority. As I said now, it is quite possible that if our prime minister wants, he can have a man of his party, but I am sure he will not do it. Still, it does happen. He does appoint a party man. An appointment comes upon confirmation of a joint session. Then even a small opposition, even a few independent members can down the prime minister before the bar of the public opinion in the world. Because we are in majority, we can have anything passed by theoretically. So the need of confirmation will invariably ensure proper choice. Therefore, I hope that this majority that majority will not be used in a manner against the interest of the nation, which goes against the impartiality of independence of the commission. I want that there should be provision in the constitution so that even in future, if some prime minister tends to be partial, he should not be able to do so. Therefore, I want to provide that whenever such appointment is made, the person appointed should not be a nominee of the president, but should enjoy the confidence of the 2/3 majority of the board. So, my lord, the idea is, my lord, that it should not be prime minister's baby, prime minister's man. Then, lordship may kindly come to page 39, my lord. Professor Subsiban Lal Saxena continues. These are my suggestions to the election, so that the election commission may be really an independent commission and real fundamental right of adult franchisee may be exercised in a proper manner. I agree that Dr. Ambedkar has said, I only want to suggest that what he suggested will not be sufficient to carry out what he wishes. Then, my lord, Sir Pataskar has said that I have carefully gone through the amendment of Dr. Ambedkar. I carefully listened to the argument at once. While I agree with him entirely that the election in a democratic form of government must be free and any sort of executive interest, I do not understand the realize of necessity, etc., etc. Ultimately, lordship may skip over this, my lord. So, my lord, what is the concern of the Constituent Assembly members? Lordship has seen Dr. Ambedkar and as well as Mr. Professor Lal Saxena. Now, lordship may come to, my lord, page 45, which is the debate on 16 June, 45 bottom, what Mr. R.K. Sidhwa has to say. Mr. President, sir, I consider this article in the Constitution as one of the most important articles as far as it is concerned. I do not think that there are two opinions in either in this house or outside the house that election should be fair, pure, honest, and impartial. If that is the view, I am sure it could be achieved only by an impartial agency, has been contemplated in the article. We want that the election above board, any machinery that is set up should be quite independent, free from any influence from any agency, executive, or anybody. Lordship may skip over 2 paragraphs, my lord. Under this article, the machinery has been set up for election purposes, while it has been made independent of the executive for the purpose of administration. Clause 5 says that the staff requires election. Then there is regarding staff, my lord. Lordship may skip over that part. And lordship may kindly come to, my lord, page 50. What Pandit Hridaynath Kunjru has to say, my lord. Page 50, last para of that, my lord. I find, sir, I made a mistake when I said that other election commissioners, regional could be removed in consultation with the chief election commissioner. They can be removed only on recommendation of the chief election commissioner. Here there are 2 things are notable. First is that only chief election commissioner can feel that he can discharge his duties without the slightest fear of incurring displeasure of the executive. Second is the removal by other executive will be depend on the recommendation of one man, namely chief election commissioner. However responsible he may be, it seems to me very undesirable that the removal of his colleagues will occupy position as responsible as those of judges of the Supreme Court depend on the opinion of one man. We are anxious, sir, that the preparation of the electoral roll and the conduct of elections should be entrusted to the people who are free from political bias and whose impartiality can be relied upon in all circumstances. By leaving a great deal of power in the hands of the president, we have given room for the exercise of political influence in the appointment of the chief election commissioner and other election commissioner and the officers of the government. The chief election commissioner will have to be appointed on the advice of the Prime Minister, and if the Prime Minister suggests the appointment of a party man, the President, who will not have no option but to accept the Prime Minister's nominee, however unsuitable he may be on public grounds. So, my lord, this is what, my lord, is under the Act. Prime Minister says X, he has to be, my lord. There's no way out that anybody else can be appointed. Somebody asked me why it should be so. I am full responsible government will prevail at the center. The President cannot be expected to act in any manner in his discretion. He can only act on the advice of his ministry, and when in the matter of patronage, he receives recommendation on the Prime Minister, he cannot, if he wants, as a constitutional head of the Republic, refuse to accept. Sir, I think therefore the draft placed before us by Dr. Ambedkar has to be modified in several respects so that the election commission may in reality consist of impartial persons. Election commissioners may be able to discharge the duties responsibly and fairly. Then, my lord, last 2 lines of the same page, my lord. For this very reason, sir, the matter ought not to be left to the sweet will of the President. in reality the Prime Minister of the day, but should be determined by law. This is not. The next page is also important, my lord, page 52. My honorable friend, Professor Sibanlal Saxena moved a number of amendments yesterday. Sir, with regard to the new draft placed before the House by Dr. Ambedkar, it may not be practical to accept some of them, but I think he has done a public service by drawing attention of the House to the glaring defects in the draft we are considering. I think it is the duty of the honorable friend Dr. Ambedkar to consider the matter carefully and to provide such safeguards as will give general satisfaction by ensuring our electoral machinery will be free from provincial influences, but also from the central political influences. We are going in for a democracy based on adult franchising. It is necessary, therefore, that every possible step should be taken to ensure fair working of electoral machinery. If the electoral machinery is defective, or is not efficient, or is worked by the people whose integrity cannot be dependent upon, democracy will be poisoned at the source. Nay, people, instead of learning more from elections how they should exercise vote, how judicious their use of their vote can be bring about changes in the constitution, reforms in the administration, will learn how parties based on intrigues can be formed, what unfair method they can adopt to secure what they want. And my lord, similarly, Najiruddin Ahmad, about sixth line, about one line I want to read it, my lord. Sixth line of his speech. Election is the most important item in a democratic setup, and it is very necessary that it should be controlled and supervised by a very competent, independent and impartial body. Lastly, my lord, so, my lord, these are the concerns, my lord, which the Constituent Assembly members have expressed, that it must be independent, impartial, it should not be at the government of the day, executive of the day. Thereafter, my lord, Article 324 comes, my lord, which says that it shall be, which is of plenary power, my lord. If your lordship permit me to read Article 324, which was draft Article 289, which gives almost absolute power, my lord, in the matter of superintendence, direction and control to the preparation of electoral roll, conduct of election of all president, vice and legislature of every state, the office of the president, parliament, etc., etc. My lord, after this, my lord, also, there were only two amendments just to complete this, my lord. One, there was a Raj Pramukh, mention of Raj Pramukh, my lord, which was omitted by the 7th Amendment. And original constitution said, my lord, even the election dispute machinery will be appointed by the election commission. 19th Amendment, my lord, omitted that provision, and my lord, this election petition, etc., has come to the High Court. Now, my lord, after the working of the constitution, there has been various reports again, my lord, which your lordship would find, my lord, page 60 onwards, various committees, which have recommended, my lord, how the procedure of appointment should be made. And Dinesh Goswami committee is one of the very important committee, my lord, which for the first time recommended that the selection committee should comprise of the Chief Justice of India. Page 60, my lord. Page 60 is the Committee on Electoral Reforms, headed by Dinesh Goswami, my lord, the then Law Minister. And at page 61, setting up of a multi-member commission. I'm so sorry.
Yes.
The committee examined the question of making the election commission a multi-member body. There has been broad agreement among all members, the commission being multi-member. Now, 1.2, as regards the mode of appointment of chief election commissioner and 2 election commissioners, the committee recommends as follows. The appointment of the chief election commissioner should be made by the president in consultation with the Chief Justice of India, leader of opposition, and in case no leader of opposition is available, the consultant with the leader of the largest party group. Consultation process should have a statutory backing. Appointment to other election commissioners should be made in consultation with Chief Justice of India, leader of opposition if not available, and chief election commissioner. So the president, my lord, the government itself is at that point of time appointed a committee on electoral reforms, which was after a trial of, my lord, 1950 to 1990, 40 years after. The committee of the government feels, my lord, there should be a committee which is independent, which should have a Chief Justice of India also as a part of the selection committee. So the next committee is, my lord, the Venkatachalia committee, my lord, which starts at page 67. And the relevant is, my lord, at page 84. Para 4.22. The commission recommends that the Chief Election Commission and the other election commissioners should be appointed on the recommendation of a body consisting of Prime Minister, Leader of Opposition in the Lok Sabha, Leader of Opposition in the Rajya Sabha, Speaker of the Lok Sabha, and Deputy Chairman of the Rajya Sabha. Similar procedures should be adopted in the State Election Commission. So, my lord, it's never visualized, my lord, and the committees after committees have found that even after the Constitution, my lord, it should not be left to the Prime Minister and Prime Minister alone. There is one more report, my lord, at page 93, Second Administrative Reforms Committee of the Government of India of 2007. And the relevant is at page 95, clause 2.
So this Chief Justice Venkatachalaya committee did not recommend inclusion of Chief Justice.
No, it did not, my lord. But it says Leader of Opposition of both houses, Speaker, and, my lord, it's a broad-based. The idea is, my lord, the Prime Minister should not have the complete say. It was, of course, my lord's notice, it was reviewing the working of the Constitution, not for specifically for this purpose. Now, another report I want to refer to your lordships is, my lord, Second Administrative Reforms Committee, which is at page 93. I'm sorry, my lord, I missed one para of the Constituent Assembly debate. I am thankful to my learned friend. Lord, page 57, if a lordship come back, what Dr. Ambedkar has to say, my lord.
Page 57.
Page 57, last para.
Last para. Now with regard
to the question of appointment, I must confess that there is a great deal of force in what my friend Professor Saxena, that 2/3 majority, my lord, said, and there is no use of making tenure of the Election Commission a fixed and secure if there is no provision in the Constitution to prevent, my lord, I find it very difficult, either a fool or a knave or a person who is likely to be under the thumb of the executive. Too strong a word, my lord. My provision, I must admit, does not contain anything to provide against nomination of an unfit person to the post of the Chief Election Commission or other election commissioner. I do want to confess that this is very important question and it has given me a great deal of headache. And I have no doubt that it is going to give this house a great deal of headache. In the USA, they have solved this question by the provision contained in Article 2, Section 2 of their Constitution, whereby certain appointments which are specified in Section 2 of Article 2 cannot be made by the President without the concurrence of this Senate. So far as the power of appointment is concerned, although it is vested in the President, it is subject to a check by the Senate, so that the Senate at any point of time when a particular name is proposed, make inquiries and satisfy itself the person proposed in a proper person. It's very important, my lord. The appointment is very necessary.
Any discussion
Yes, my lord.
in Chief Justice Venkatachalaya committee report
Yes, my lord.
as to why they did not accept the earlier report of Dinesh
Dinesh
Goswami?
no, there is no reference to that. My lord.
There is no.
There is no reference to that, my lord. There is no reference.
Just point out because Justice Venkatachalaya committee was on working of the constitution. So they were looking at all the provisions of the
But
constitution.
the earlier committee is also working of the committee.
Yes.
It's not particularly.
Dinesh Goswami report.
This is also. Achha, this is Committee on Electoral Reforms.
That was on electoral reforms, my lord. Dinesh Goswami committee was on electoral reform. And when I come to, my lord, the law commissions also, my lord, there are certain things there. Yes, yes. After this, I wanted to invite your lordship's attention to page 93.
Is it so because if the CGI is the member,
Yes.
there could be some inconveniences, some problems?
But there cannot be any inconvenience, Lord.
Just asking you whether
Lord, I don't,
anywhere have you.
I have not seen anything, my lord, that anyone has expressed that there will be inconvenience, my lord. In fact, the CGI is a member of the, my lord, Lokpal appointment committee. He is a member of the Delhi, the CBI director appointment, my lord. Even CBI director. CBC Act. Because Lokpal Act has amended the Delhi Special Police Act. Section 4A is inserted, saying that the Chief Justice of India will be part of the selection committee. Even a CBI director can be there, my lord, definitely, my lord, election, there is no question of inconvenience. All that we are looking for is an impartiality. We have a face, my lord, who, it's not that you cannot be removed, but the who is appointed. That's why your lordship's collegium system, I'll come to those judgments, my lord. We must have faith in the person. And today, my lord, with great amount of respect, I don't want to say any disrespect, but there's slogans which are shouted in public meetings against the Chief Election Commissioner and commissioners, my lord. Just a minute, Mr. Solicitor, we don't run away the facts. We do not run away from the facts. Yes, this is a constitution. It has to be seen, my lord. I have never seen, my lord, in a public meeting, Chief Election Commissioner, it pains me, my lord, that election commissioner have been said with words, my lord, which I don't want to utter in this open court. And meeting after meeting, why no action has been taken, my lord? It should have been taken. That party should have been banned, according to me, my lord, for saying so. It's a model breach of model code of conduct.
Some mob goes and, my lord, makes abusive words against the honorable judges. Lord, should we dismantle the collegium system? What is this argument?
Yes. What is this argument? Is the court for to consider? Mr. Solicitor, I am not trying to convince you. I am trying to convince the court only. What I am saying, my lord, with this also, no action is taken. Why should not the action be taken against that party? My lord, may I come to it now on page 93? Page 93 at 95.
We would appreciate that when one senior counsel is addressing us,
yes, my lord,
no one else should enter.
Grateful.
We are extremely grateful.
Yes, precisely.
I was not going anywhere else.
We are there to check in. If he goes beyond his bounds, we will stop.
He had already, I'm sorry. Anyway, he had already.
You know, in course of argument, Mr. Solicitor, you have been also in this profession for so long. Course of making submissions, sometimes you have to go a little here and there.
It is directly on the point, my lord. I'm saying whether we had confidence in a system where we are constitutional fathers thought that. Anyway, page 95, my lord. May I just go to page 95? Appointment of chief. This is by the, my lord, a committee, second administrative reforms committee, on the report on ethics of governance, etc., by the government of India. At page 95, para 2.1.5, appointment of Chief Election Commissioner, Election Commissioner. The present procedure of appointment of the Chief Election Commissioner and appointment and other election is laid down in 24, stipulates that they are to be appointed by the President on the advice of the Prime Minister.
Yes.
During the debate, page 96, in the Constituent Assembly on the procedure for appointment, there were suggestions that the persons appointed as Chief Election Commissioner should enjoy the confidence of all parties, and therefore his appointment should be confirmed by 2/3 majority of both houses. Even at that stage, there were views that the procedure for appointment should be broad-based one and not confined to one person, my lord. Above all party consideration, in recent times for statutory bodies such as NHRC, CVC, appointment of chairpersons and members are made on the recommendations of broad-based committee. Thus, the appointment of Chief Vigilance Commissioner committee consists of Prime Minister, Home Minister, Leader of Opposition, whereas NHRC committee is chaired by the Prime Minister and its members, Speaker of the House, Home Minister, Leader of Opposition in Lok Sabha, Leader of Opposition in the Rajya Sabha, Deputy Chairman of Rajya Sabha. Given far-reaching importance and critical role of the Election Commission in the working of our democracy, it would certainly be appropriate that a similar collegium is constituted for the selection of, when you say collegium, my lord, it's from different fields. It can't be, my lord, the same person nominates one and then he appoints. Constituted for the selection of the Chief Election Commissioner and the Election Commission. Recommendation, the collegium headed by the Prime Minister, Speaker of the House, Leader of the Opposition of the Lok Sabha, Law Minister, Deputy Chairman of Rajya Sabha as members should be made recommendation as consideration of the President. It's similar to, my lord, Venkat Chelia Committee report. Now, what is important is, my lord, Law Commission of India, 255th report, my lord, which starts at page 98. CGI. Two 255th report, my lord, is on electoral reforms again. Page 99, para 6.1. The ECI is an independent constitutional body which has been vested with the powers of superintendence, direction and control of the preparation of electoral roll for as the conduct of all parliamentary state elections and the elections of the president of the vice president or so and so. 6.3. Article 324(5) of the Constitution intended to ensure the independence of ECI and free from external political interference and thus expressly provided for the removal of CEC. Removal is like the Supreme Court judges, my lord. Now the appointment part is, my lord, the recommendation, lordship, may kindly come to, my lord, page 101. Recommendation, para B, appointment of Election Commissioner and CEC. Appointment process, the first it has been quoted. And now the final recommendation is page 103, para 6.12.1. Recommendation of the Law Commission. Given the importance of maintaining the neutrality of ECI and to shield CEC and Election Commissioner from executive interference, it is imperative that the appointment of Election Commissioner be a consultative process. To this end, Commission adopts
12.2.
Yes, my lord.
The recommendation is
to
that
12.2.
CGI should
Yes.
one of
To this end,
Yes.
the Commission adopts the Goswami Committee with certain modifications. First, the appointment of all election commissioners, including CEC, should be made by the President in consultation with the three-member collegium or selection committee consisting of Prime Minister, Leader of Opposition and Chief Justice of India. The committee considers the inclusion of the Prime Minister as important as representative of the current government. So, my lord, this is, and then lordship would kindly find, my lord.
This was really same. Reiterate it from
Okay.
that's it.
So, my lord, lordship would see, my lord, before the making of the constitution, by the various committees, during the debates, and post the constitution, my lord, various committees from time to time have recommended that, my lord, it has to be multi-member committee, so it cannot be at the wishes of a single person, single individual, as is the Act has provided. Now, in this light, my lord, the Constitution bench in the Hon'ble case had dealt with the aspect at a great length, my lord. Would you now, lordship, take it up, my lord, the volume 3.
Page 93.
Page 93 of this, because first I have given the two other judgment, Mohinder Singh Gill and T.N. Session. Page 93. Is, my lord, Arnav Barnwal judgment by a constitution bench. Opinion delivered by Honorable Justice Joseph, and there is a concurring opinion by Justice Astogi. The judgment starts at page, my lord.
93.
93. The main
144.
judgment starts at page 144. And 147. So, just submissions of Mr. Gopal Singh Karnan are noted, my lord. And para 38 are this, lord, which I have read to your lordship, lord. The historical perspective of the committees and the Constituent Assembly debates are there. And para 84 to 86 is important, my lord. Lordship would permit me to read that. Page 183. इसका page is not open. Para 84. It is clear that founding fathers intended that the elections in the country must be under superintendence, direction and control of an independent body. The body is Election Commission of India. Under Article 324, the Constitution, the Chief Election Commissioner is an unalterable feature or figure. A commission can consist of only Chief Election Commission. A multi-member commission was also contemplated by the founding fathers. However, the post of election commissioner was need-based. For nearly 4 decades, there was no election commissioner. As we have noted that on 1989, first 2 election commissioners were appointed. In that regard, the appointment of the chief election commissioner and the election commission, the constitution does not provide any criteria. It does not fix any classification. It does not prescribe any disqualification in the matter of appointment, either as chief election commissioner or election commissioner. The appointees have been bureaucrats drawn from civil services. 324(5) deals with conditions of service. Then para 86. The first proviso to Article 324(5) acts as a guarantee against the removal of the Chief Election Commissioner, except on like ground, a similar manner, a judge of the Supreme Court can be removed. The conditions of service of election commissioners shall not be varied to his disadvantage. This means Parliament cannot, or the government by rules, either remove Chief Election Commissioner except by impeachment in the manner provided for removal of a judge of the Supreme Court, nor the Parliament can make law, nor the government or rule vary conditions of service of Chief Election Commissioner. The proviso to Article 325 operates as a singular insulation to protect the Chief Election Commissioner either from being arbitrarily removed or his conditions of service being varied to it. But as contemplated by the founding fathers, the protection against arbitrary removal or protection against varying conditions of his appointment were not sole safeguard so far as far more vital was the appointment of the right man and the need to take out of the exclusive hands of the executive. But this is what the ratio of the judgment is, my lord. I'm just submitting. And now, lordship, may kindly come to para 106, my lord, which is page 196. It deals with the cases regarding separation of power and judicial activism. And at para 111, page 197, separation of power has been held to be a basic structure of the Constitution. Page 111, Indira Nehru Gandhi is quoted, the principle of separation power is not a magic formula for keeping the 3 organs. 112 is important, my lord. Separation of power is understood as prevailing in India, constitutes a part of the basic structure of the Constitution of India. See Keswanan Bharti. Then Indian Aluminium, adjudication of the rights of the party is an essential judicial function. Now, my lord, I will show to your lordship, my lord, the Election Commission exercise varied judicial powers also, my lord. So it has to be an independent person completely. And the appointment process has to be independent. The adjudication of rights of the party is an essential judicial function. The legislature has to lay down the norms and conduct of the rules which will govern the parties, and transactions require the court to give effect. Now, Roman 4, subclause subpara 4 of para 56, courts in their concern and endeavor to preserve judicial power equally must be guarded to maintain the delicate balance devised by the Constitution between three sovereign organs functionaries in order that they know that the rule of law permits to fulfill the constitutional obligations of establishing an egalitarian society, respective sovereign functions, etc., etc. Lord, may skip over that part, my lord. Lord, may kindly come to page 198, para 116. Separation of power is a part of basic structure of the Constitution. Equally, judicial review has been recognized as a form of part of basic structure. Judicial review of a legislation is expressly provided in Article 13. A court, when it declares a law by legislation unconstitutional, if it be that it is within its bound, cannot be accused of transgressing the principle of separation of power. Declaration of a law made by the Parliament as unconstitutional form part of its power. In view of the enunciation of the doctrine of basic structure in India, unlike perhaps in most countries, even an enactment to the Constitution can be declared as unconstitutional by the court. Such exercise cannot expose the court to the charge that it is not observing the limits of the Constitution. Then Lord may skip over regarding judicial review. Lord may kindly come to para 186, my lord. Page 224. Para 186. My lord, what is important is that the court noted in Anukul that holding free and fair election constitute a basic feature of the Constitution and approved of the view apparently that the right to elect is fundamental to the democracy. Even as treated as statutory right, at any rate, cannot be divulged from or separated from the mandate of 326. The right is of the greatest importance and form the foundation of a free and fair election, which in turn constitutes the right of the people to elect representatives. We would, for the purpose, list the question rest here to process said. Then democracy, my lord, Dr. Ambedkar's speech is quoted, my lord. I have read to your lordship that. And lordship may kindly come to para 200, my lord, at page 229. Article 324 is a plenary provision clothing the article Constitution Election Commission with the entire responsibility to hold national and state election and carries with it the necessary power to discharge its functions. However, the Law Commission cannot act against a law framed by the Parliament or state legislature. The power of the Commission is also subject to the norms of fairness and it cannot act arbitrarily. The action cannot be mala fide. Article 324 governs in the matters not covered by legislation, being a high constitutional functionary which is expected to function fairly, legally. If he does otherwise, the court can veto the illegal action. See Mohinder Shinghil. Now, my lord, 201. Election Commission under 324 can postpone election on the basis of the opinion that there exist disturbed conditions by the state in the state or some area of the state, thus making of holding free and fair election not possible. This court followed Mohinder Shinghil in democracy depends upon the man as much as the Constitution. Election Commission is endowed with the power to recognize political party, to decide disputes arising from them. It can also adjudicate controversies or splinter groups within a political party. The right, this is, my lord, where judicial power comes, my lord. I'll show to your lordship later. The commission has also been found to have power of issue of symbol order. This site is traced to Article 324. Then, recognizing the magnitude of exercise of control is fair in election, this court declared that in case of conflict of opinion, the opinion between Election Commission and the government, as education of machinery to deal with the state of law and order, assessment of Election Commission was to prima facie prevail. This court no doubt observed that mutually acceptable conditions so and so. While dealing with the power of the Election Commission to the requisite staff, for election duty disagreeing with the commission, it could require the service of the employee of the Bank of India. This court declared the election commission did not have untrammeled power. The power must be traced to the constitution. Election commission has the power to issue directions to conduct elections, requiring the political party to submit details of the expenses incurred or authorized by them for the purpose of election of their respective candidates. The power was traced to the conduct of election. All the powers of election, though not specifically provided but necessary for effectively holding elections, are available to the election commission. So 324 is the reservoir of power. Now, Lordship may kindly come to my Lord, para 207. From a spate of violence in the state of Gujarat in the dissolution of assembly, the commission took the view that it will not be possible to hold election, though 174 mandated there shall not be more than 6 months between. After finding that 174 did not apply to the dissolved assembly, it was indeed held that this court reiterated the words that superintendence, direction, and control and conduct of election were the broadest term. This court also found that there are no free and fair election. This is the end of democracy. Now, my lords, this is on the width of the power of the election commission. Lord, I have a separate chart, my lord. I will invite your lordship's attention to that. Would your lordship now kindly come, my lord, para 213. 213. And 214, it's very, very important, my lord. To page 233, para 213. We would therefore find that the Election Commission of India has been charged with the duty and blessed with extraordinary power to hold elections to both Parliament and the state legislature from time to time. This is an enormous task. The power it possesses under Article 324 is plenary. It is only subject to any law made by the Parliament or by the state legislature. Undoubtedly, the Election Commission is duty-bound to act in a fair and legal manner. It must observe that the provisions of the Constitution abide by the direction of the court. The same being done, it can draw upon a nearly infinite power of the reservoir power of power. Once a poll is notified, which again can be called to be taken by the Election Commission itself and indeed capable of being misused and subject to considerable controversy if bias, subservience of the power, that is betrayal, it assumed unusual powers. Its writ lies across the government over the length and breadth of the country. Officers of the government who come under it charge become the subject to the superintendence of the commission. The fate of the political parties, its candidates, and therefore the democracy itself, to a great measure, is allowed to rest in the hands of the Election Commission. We may therefore be the officers, while there may be officers who assist the commission, virtually important decisions has to be taken by those at the helm of affairs. It is the Chief Election Commissioner or Election Commission at whose table the buck must stop. It is in this scenario we bear in mind that when a decision is taken in the process of holding the poll, that's subject to proceedings which are initiated in the court, which conduce to the effective holding of the poll, any proceedings which seeks to bring the election process under a shadow of taboo. The significance of this aspect is that it adds to the enormity of powers of the responsive to Election Commission. Awaiting outcome of the poll and to question the Election Commission before the tribunal may result in illegal, unfair and malafide decision of the Election Commission passing under the muster of the day. Once the elections results are out, the matter is largely reduced to a fait accompli. In fact, at many a times, an omission or a delay in taking decision can itself be fatal to the holding of free and fair election. The relief vouched in an election petition may not by itself provide a just solution to the conduct of election in an illegal, malafide or unfair manner. These observations have a direct connect with the question which are concerned, namely the need to take an appointment of the members of the Election Commission out of exclusive hands of the executive, namely the party which are not unnaturally has an interest in perpetuating its power in itself. So that is the question posed, my lord. And lordship would kindly now come to my lord. Para 206 is not necessary. That's all right. We can go on reading it.
And unrelated evil, and unrelating abuse, service with the way of democracy.
That's all. Para 220, my lord, equally the sterling questions which we have described, which must be possessed by the Election Commission, is an indispensable for an unquestionable adherence to the guarantee of equality under Article 14. The wide spectrum of powers the Election Commission exercise them unfairly or illegally, as much as it refuses to exercise power. When such exercise becomes a duty, it has the telling and chilling effect on the fortunes of the political parties. Inequality in the terms of matter of treatment of political parties who are otherwise similarly circumscribed, unquestionably balanced, so and so. Political parties must be viewed as an organization representing the hopes and aspirations of its constituents who are citizens. Lordship may ignore, my lord, this part of it, although. Then Lordship may kindly come to, my lord, that there is a power under the symbol order. And, my lord, Lordship may straight away come to para 248. 222. Sorry. Yes, I'm so sorry. I missed one para. Para 222. That's right. Page 236, my lord. Para 222. The Election Commission, including Chief Election Commissioner, blessed with infinite power and who are able to abide by the fundamental right, must be chosen by the must be chosen not by the executive exclusively and particularly without any objective yardstick. Lord, this is the ratio of the judgment. I mean, reiterated in further paragraphs, my lord. So it is very clear, my lord, it cannot be chosen by the executive exclusively and without any objective yardstick. Now, Lordship may kindly come to, my lord.
Ansari, just one moment.
Yes.
Please come to 146.
146. My lord. Page 146.
Starting page of the judgment.
Yes, my lord.
Para 3.
Yes, my lord.
I'm looking at prayer 1.
Yes, my lord.
Of WP Civil 104.
Yes, my lord. May I read that?
Which was the lead petition.
Yes. Mandam.
Prayer 1.
Yes.
And you will have to answer.
Yes.
Or you will have to show us from the judgment.
Yes, my lord.
Why this prayer was not granted.
May I just read the prayer?
If prayer had been granted, that would have been the end of the matter.
Please, your lordship. May I just read this, my lord? Issue a writ of mandamus, an appropriate direction or order, directing, commanding the respondent to make a law, ensuring fair and transparent process for selecting by constituting neutral and independent collegium selection to recommend the name of the appointment of Election Commissioner of the Constitution of India. What
so
prayer is, my lord?
This prayer with 222.
Yes, my lord.
Why did the court stop at?
Lord, it says it is a neutral and independent collegium selection committee. Neutral, independent collegium.
Once it is said in 222,
please, your lordship,
that
it cannot be left.
Collegium should not be
comprised
of persons.
Of executive exclusive.
Because the election commissioners have to be chosen not by the executive exclusive.
Please, your lordship, Lord.
Right. So why did the court stop?
No, it has gone further, my lord. I'll show
you. That you have to
show.
What is the reason? Just show.
Yes, my lord.
That paragraph.
Yes, my lord.
You stop.
301.
248.
Yes.
Independence. Independence the meaning actually 248.
Page 245. Concept independence. Yes. Independence and sterling and indispensable attribute. What the prayer is, my lord, that it must be neutral and independent collegium. That is what is expected, and what the 222 said, it cannot be executive alone. And further discussion is here, my lord. 248 onwards, my lord. I may have, yes, para 248, page 245. Yes. What is independence? Independence is a value which is one of the elements in an amalgam of virtues that a person should possess. The competence of a man is not to be in conflict with fierce independence. A person may be excellent, that is, at his chosen vocation. He may be excellent administrator. He may be honest, but the quality of independence transcends the contours of qualities of professional excellence as to the dictates of the honesty. We may no doubt clarify that ordinarily honesty would embrace the quality of courage, of conviction flowing from perception of what is right and what is wrong, irrespective of consequences to the individual. An honest person would ordinarily be unrelenting, take on high and mighty, preserve his righteous path. An election commission is answerable to the nation. The people of the country look forward to him so that the democracy is always preserved and fostered. We may qualify the above observations by stating that true independence of a body of persons is not to be confused with sheer unilateralism. This means that the election commission must act within the constitutional framework and the laws. It cannot transgress the mandate of either and still claim to be independent. Riding on the horse of independence, it cannot act in an unfair manner. Now, independence must be related finally to the question, what is right and what is wrong. A person who is weak need before the powers that it cannot be appointed as an election commission. A person who is in the state of obligation or feels indebted to one who appointed him fails the nation and can have no place in the conduct of election, forming the very foundation of democracy. This is the answer, my lord. What your lordships have laid down the guideline, my lord, that you cannot leave it to the person, my lord, who will appoint him and then he feels obligation for his lifetime and he feels indebted. An independent person cannot be biased, holding scales openly even in the stormiest of times, not being servile to the powerful, but coming to the rescue of the weak and wrong, who is otherwise right, would qualify as true independence. This is the test, my lord, whether we have a system which selects a person who is not obliged to a person. 2251. Upholding the constitutional values which are in fact a part of the basic structure, which includes democracy, rule of law, right of equality, secularism, purity of election, otherwise would indeed proclaim the presence of independence. Independence must embrace the ability to be firm even against the highest. Not unnaturally, uncompromising, fearless will mark an independent person from those who will pull hold by holding their karma. In the context, we feel advised to refer to the following discussion in the AOR Association case, the 4 judges case. A little personal research would result in revelation that the concept of legitimate power of reciprocity debated by Benin in these articles, the basis of power and power of interaction model of so-and-so influence, in addition to having dealt with the very physiological regions which influence the personality of an individual, reference was also made to the legitimate power of reciprocity. It was pointed out that the reciprocity norm envisages that if someone does something beneficial for another, the recipient would feel an obligation to reciprocate. In view of the view expressed by the author, the inherent indeed of the power is universally available in the subconscious of the individual. On the satisfaction of the achievement of the desired power, there is a similar unconscious desire to reciprocate the power. It is important that the appointment must not be overshadowed by even a perception that the yes men will decide the fate of the democracy, that all it promises. Certainly the darkest apprehensions from the founding fathers, as buttressed by the reports and other materials, unrelentingly point to the impression. So, Lord, this is what the independence means, my Lord. There should be no reciprocity, there is no obligation, there is no indebtedness. Further, my Lord, this court has further, in more clearer terms, has said in the subsequent paragraphs, which I can just refer to your Lordship, my Lord. Page 263. 263, para 301. Yes. May I read from 299, my Lord? Para 299, page 263. It may be true, my lords, about it, that the Election Commission of India provides its services to certain countries. That, however, does not deflect this court from providing what its founding fathers contemplated and also advocated in various reports. It may be true that the Election Commission of India were appointed for the 4 decades of the Republic and thereafter. Since the year 1993, Election Commission has become a team which consists of Chief Election Commissioner and 2 election commissioners. It may be true in the sense that the President, acting on the advice of the Prime Minister in accordance with the rules of business concerned, has been making the appointment. However, it is equally clear that Article 324 has a unique background. The founding fathers clearly contemplated a law by Parliament and did not intend the executive exclusively calling the shot in the manner of appointment of the commission. This is what your lordships have found in the Constitution bench. 7 decades have passed by. Political dispensations are varying use, which have held the reign of power, have not unnaturally introduced a law. A law could not